Hi, okay, so MEE prediction. They missed Civ Pro last time, so Civ Pro high on the list. Contracts is up there because they have tested it twice in a row, so that could be a contender. And then secured transactions for sure. Skip evidence and real property. I think it's going to be corporations for sure. Could be wills too. That's like your medium tier, and then wills, medium tier, okay? Then corp trust. Looks like they might do it again. Family law looks good. Torts looks good too. Maybe one with a child. Okay. Contracts, wills. Evidence too. They've done twice in a row. And real property they've done twice in a row as well. Okay, real property. I don't think partnerships. Okay, that's my predictions. So let's get more into what they've tested in civil procedure. As you can see in the top here, they started in 723 3 times, and then in 2021. So let's see what they tested and what they haven't tested in a long time. So statute of limitations, motions for summary judgment, impleader, personal jurisdiction, venue, joinder, subject matter jurisdiction, pleading requirements, pleading fraud, joinder, again, here we go, res judicata. So I would say another res judicata one, and with a little bit of what I haven't seen here. Res judicata and pleading requirements. Watch out for these. Exclusion and pleading requirements. Whether it's fraud or secured transactions is secured transactions. I don't think I need to go over that. Corporations. So they did a run here in 722 for 3 administrations, 722. So they did acquiring land for the company. So some fiduciary duty stuff, duty of loyalty, right? Some dividends, some more duty of loyalty stuff, derivative actions, fundamental changes, voting rights. I'd say voting rights again this time. Look out for that one. Okay, trusts. They did it 723, 722. So it was this state A statutes terminating a trust, beneficiaries consenting to termination of a trust, reinvestment of trust income, rule against perpetuities implication, revoking a trust again, duties, and then they had some intestate succession stuff at the bottom there. Child support. So looking after the beneficiary stuff again, right? The child support. Living persons have no heirs. Oh, that's that spendthrift, I think. Revision of trust, resulting trust. Okay, and then after that it goes back really far. 219 and 718. Hospital bill. So it's like a discretion kind of things that you need, necessaries, right? Okay, child support again. That looks pretty good actually for this time. Let's look at 718. Pretermitted children. Okay, I would say pretermitted omitted children, discretionary. So family law, let's see what they'll do for family law. They haven't tested since 721 and then the pandemic exam. So looks really overdue here. 721. SMJ over child support and custody, personal jurisdiction in there. Modification of child support. I don't know. It seems like family law is family law. I don't know if I want to go into it further. Okay, torts. Torts. Last time they tested was July 23 and July 21. And I remember there's one about the big box, the kid one. And I feel like, so this one's about pesticides and negligence, right? So let's look at negligence. And then 219 must have been the big box one, the kid one. And I feel like they like the kid thing, but so it's another negligence one. And it's about the accident, right? So negligence twice in a row, 717. Abnormally dangerous activities, the fireworks. So I think this time it's going to be abnormally dangerous activities again, and or children. Somehow children. Okay, let's do the wild cards. Contracts. Why am I doing contracts? Oh, because it's tested so much. Let's just look at what they tested last time and the last few times and stay away from that. Well, not stay away from it. Of course, be ready. But I'm just saying 722 and 222. Some common law thing here. I wonder if the recent one was UCC. So this one was, oh here, UCC. So let me see. Okay, it looks like UCC. So UCC, common law. So if anything, it should be common law. And then evidence. So judicial notice and 223 and 722. 223, 722. prior testimony, impeaching the witness, more witnesses stuff, competency. So I would say hearsay. Real property, they just tested it, but they like testing it. So there were tenant. So some tenant stuff. Now let's go back here. 223 and 722. Adverse possession. Adverse possession. So it's a crossover with wills. Fee simple determinant. So the present or the estates. Okay. I don't know. Conveyances? And wills. I think wills is wills. All right. Let me know if you want to talk about it further or reach out in the comments. So first thing is civil procedure. I think they will test that one for sure. 6 subjects, 6 essays. I think that's my number one prediction. And what I haven't seen in a while, just going back, is the preclusion. I haven't seen that for a while. And pleadings, the FRCP requirements for pleading, and also fraud pleading.
Normally, under the federal rules with pleading, remember they go by notice pleading, has to be a short and plain statement to put the defendant on notice as to what is going to be pled. And the exception to that is fraud. So you want to make sure that fraud, it needs to be in detail. There needs to be facts sufficient to lay out the claim for fraud. So you want to know the distinction on that. And then most states, they don't go by notice pleading. They go by fact pleading. Most states go by fact pleading, where you need to give a detailed account of the facts to support the claim. So there's a big distinction with that. And when it comes to fraud, you need to have more so fact pleading that there's enough to indicate specifically how the fraud was created. So that's an important distinction in procedure.
Right. Their buzzword that they use is particularity. So if it's fraud, you have to plead with particularity as to how the fraud occurred.
Then it's important to know, once the complaint has been pled, is to know the different types of responses outside of just the answer. There's the motion to dismiss, motion to strike, and motion for a more definite statement.
That's civil procedure. So the next one is secure transactions. And as I was doing it, I was thinking, in your years of practice so far, Walt, have you ever done anything with secure transactions before?
Actually, I have.
Nice. Okay.
Yeah, go ahead.
So looking at the model and selected answers, I see attachment, Article 9 is a governing law. I'm just naming off little things that I remember. Perfection and priority, and then the PM purchase, money,
Security interest.
So I'll let you elaborate.
Yeah, so I think the main thing with secure transaction that's important is to understand the way priority works, because the priority can affect the ultimate property that's being the creditors are trying to claim. So with the purchase money security interest, that would take priority typically over everything else. And just understanding those types of priority interests, because once you understand that, then everything else will fall in line. So the other thing is to know how something is secured or if it's attached, and the elements to that, and also putting the rest of the creditors on notice. So that becomes important, and sometimes you'll see that as a crossover in property, because even though bankruptcy is technically not on the bar, but some of the secure transactions and creditors taking various priorities does involve a lot of bankruptcy. So with the secure transaction, if someone has a lien, you want to understand the lien, junior liens, and how that impacts the overall sale of a transaction. Because if a senior lien is foreclosed on, then what it could do is it could wipe out the other junior liens on the asset. And there's different ways that a junior creditor has to claim their interests. And sometimes a junior lien holder will make a claim to try to foreclose, but they can only take subject to a senior lien or a purchase money security interest. So that's important when it comes to sell, is just knowing the ins and outs of the priority of creditors. So then the next subject I'm looking at is corporations. You see, it's been tested so much in the past years, 9 times, but it's skipped over 3 times. I looked, and the thing that I haven't seen for a while beyond the last time was voting rights. So understanding the voting rights of not only the shareholders, but the board of directors
too, actually.
And also, I know sometimes with the voting rights, it's knowing how they're pulled and understanding the elements of proxy votes. And if someone is not there, also what happens when there is a shareholders meeting, how that shareholder meeting ends. A lot of stuff that also comes up are derivative suits, knowing the difference between a direct lawsuit and a derivative, whereas a derivative is a lawsuit based on behalf of the shareholders, and knowing when the lawsuit is won, where that money goes. A derivative suit is basically a lawsuit brought by the shareholder on behalf of the corporation against the directors, officers, or those who breach their duties. Another thing that comes up a lot in corporations is the business judgment rule. So you want to always be cognizant of that. Basically says that if the corporation acts in good faith and you can show that, the courts will not interact with it. So a lot of times corporations who do an alleged wrong will try to use the business judgment rule as a defense that the court shouldn't intervene and that it was based upon good faith of the corporation.
And it was an innocent mistake.
Or sometimes it's not as innocent, but what they'll say is that it's for the best interest of the corporation. That's why they had to do that. So that's a defense that is typically used in corporations.
So for the next subject, trust. I know why I wrote discretionary accounts. So spendthrift, those kinds of clauses I haven't seen in a while. And yeah, it must be the irresponsible children.
And with trust, it's just understanding the different trusts and why you would want to have those. So there's the discretionary trust where that's at the discretion of the trustee, and then understanding the creditor's rights once those are distributed to the beneficiary. Because a spendthrift trust, then there's hurdles as to the creditors trying to get money from the beneficiaries. But it's also important to understand the exceptions to a spendthrift trust or discretionary trust as to where the creditors can come in to get the money from the beneficiaries.
I was talking about child support and how if alimony and child support is due, that they can get around the discretionary trust.
They can evade and they can get access to those amounts. So there's 4 or 5 main distinctions as to how to get around when there is a spendthrift clause in some of these trusts. And so it's just knowing how a creditor could come in and get the money that is going to the beneficiary.
Yeah.
And also from the trustee's point of view, right? If you have a discretionary trust, the trustee has the discretion to distribute that or not. And so it's understanding everybody's role from the beneficiary, the trustee, and the creditors, and knowing everybody's rights.
Next is family law. It seems to me a narrow subject. Last time we had spousal support, alimony, and then child support, and then modification of the child support. It didn't seem that much to know.
Yeah, I think with family law, the most important thing to remember with family law is the standard. When it comes to children, that's the best interest of the child. So you want to just think public policy, what's the best interest of the child? Sometimes the family courts say it's best to keep children together that are in the same family. So if you have different family members, the court tends to look at, okay, is it better to keep the siblings together with the parent? What's been the history? And so with family law, you can get creative, but you always want to think of the best interest of the child. Another thing that comes up in family law a lot is when you're dealing with two states who might have competing laws. And the important thing to remember is that one state has to acknowledge and give credit to the other state's ruling. And then as far as when it comes to divorce and splitting up the assets, a lot of times it's looking at, you want to incorporate a lot of the facts in the essay. And one of those things is how long have the parties been married, when and where, and how these assets have been accumulated. And when you look at issues as far as equitable distribution, obviously the longer a party has been together, then it's going to be more evenly divided. If a person has just gotten married, then you want to think of a little bit of contract law, whether there was a prenup, you can still have an annulment. Then again, you want to bring in common sense and say, well, if this couple's only been married for a few months, this spouse is bringing in this amount and this spouse comes in with a bag, then how fair is it to split it evenly when there is a divorce? So with family law, you always want to bring in common sense when you don't know the law. And when it comes to children, you always want to mention the best interest of the child.
Right. Next subject is I wrote an act by a child. So there was this one prompt about big box where this this child was careless. They had an eye impairment, and the child didn't listen to the mom and broke free and did all this stuff. So, and then I think before that, I remember there was some kind of snowmobiling incident with these kids that ran into a chain or something like that. So I put down an act by a child. They do the whole, if it's an adult activity, we apply that to the child.
Yeah, age,
Yes.
intelligent. It comes to torts, all encompasses negligence, right? And so when it comes to the child doing something, you want to look at, is he engaged in an adult activity? And a lot of times it's not clear cut. You want to argue the facts as to whether it is or is not. If the child is riding a snowmobile, you want to argue both sides and give arguments to why it is or isn't an activity, just so the bar examiners can see that. And then also whether the parent is responsible, whether we can incorporate that argument as to the parent being responsible. A lot of times, if it's a one-off, then you want to discuss that. If this is a child who's known to be bad and he tends to run off and do things, you want to discuss that as well, because then the parent could ultimately be responsible. And it's a form of vicarious liability, getting to the parent based on them being negligent with the child. So if a child comes in and let's say every day he throws rocks at a house and the parent is aware of it and eventually the glass breaks, then the neighbor could sue the parent based on that, because they knew that the child goes out and throws rocks at the house every day.
So parents are responsible for the children if they know of this frequently occurring and they don't do anything about it. The liability goes to the parent. If it's just a one-off thing that this kid does, probably not responsible. There was this one thing I wanted to say with torts and children that I haven't seen addressed in any of the essays, is there's a minimum age where negligence can be attached to a child's act. I believe it's 7 in most states.
I believe it is 7 in most states.
Right.
And then also a big thing that comes up is also the attractive nuisance anytime you have children. So you want to make sure to understand the elements of the attractive nuisance doctrine. And then obviously the defenses of contributory comparative negligence.
But very young children under 4 will generally not be held liable. And I have seen 7 somewhere. I can't pull it up right now, but I have seen 7, and that totally went in with that big box essay prompt that I was telling you about, where the kid had impairment and they were asking whether it was negligent or not. He was age 6. So I didn't see any of the model answers address that at all. I mean, it's a very limited amount of time, but perhaps a little line on that. Depending on the jurisdiction we're in, some children will be too young to be held liable for negligence, right?
I mean, another one I was thinking is just knowing the abnormally dangerous activity that could come up too with children, and just knowing that.
Yes. So the next subject, a wild card, is contracts. It was just tested UCC last time. I think it was about a diamond ring or something. So now I'm thinking if they do test contracts, it'd be common law, some kind of service.
There's different types of contracts. You just want to figure out where you're going. A lot of times it's either the formation, what deals with offer acceptance, consideration, and there's a breach. There is an issue with format of the contract and whether there is a contract. And then the other part is when you do have that contract and there's a breach, if it's material or not, and then discussing the remedies of that. So you want to hone down all the contract remedies, because they're always going to come up anytime you do talk about contracts. And then the defenses. Speaking of kids, just know that the defenses to formation at the onset, infancy, intoxication, pacitation, and then whether that party was under duress or not. And then you want to think of maybe obviously the statute of frauds. So just common law contracts, there's so many areas that could be tested on, but typically they're clustered into the formation, or when there's already a formation, whether there is a breach. And then another hot topic is anticipatory repudiation, and just knowing the elements of when there is a contract and if that one party has breached the contract that has already been informed. And then what do you do? The 4 things that need to be done pertaining to anticipatory repudiation.
And then the next subject after that, I have evidence, and I haven't seen hearsay for a while.
Yeah, hearsay is obviously, we know from law school, there's a lot of things to discuss and to know with hearsay and what's non hearsay. And the thing that can get people mixed up is first just trying to figure out, is the situation criminal or is it civil? Because we know certain rules for civil and criminal. So it's just understanding what arena we're in. Are we in the criminal courts? Or are we in the civil courts? And then outside of that, it's just honing in. Is the witness, are they available? Are they unavailable? And then understanding the testimony, whether it was under oath and whether we can bring that into court. But evidence is so broad. Obviously, we want to understand the hearsay and their exceptions and understanding present state of mind and all the rest of the well-tested exceptions, because we know those are going to come up with evidence.
Yes. Next subject after that, real property. I haven't seen conveyances in a while. So the deed, delivery, acceptance.
Yeah, it's important to understand the ins and outs of one, the requirements of a deed, and then you have different methods of delivery. You have face-to-face delivery, whether it's to a third party, and on some of the deed delivery, you want to understand, does that person who is delivering the deed, are they giving up control? Because if they have power to take the deed back or alter their position, then it's technically not a valid transfer. And then it's understanding the different types of deeds. You want to know the 6 main general warranty deed, what that comes with in a deed, and then those covenants of what the present covenants and then the future covenants once the deed is transferred. So I anticipate those coming up on the property question.
Yes. Okay. I got will. Say will formation. What you need for a will.
Yeah, I think with wills, it's understanding, does this person want to have capacity to enter into the will? Are they aware? And the will written, and we have the formation of the will, and then how a divorce or how a child passing away or even our beneficiary in the will, how that is going to alter the will going forward. Also looking at how an advancement affects the will, and or you want to look at whether there is an item that is no longer there. If the certain property contained in the will has a deemed, and what that does to the rest of the beneficiaries under the will. And you always want to remember and discuss what is the present intent of the testator. So there might be an issue with formation, but then use the facts to your benefit as to whether there was present intent, and always refer back to the intent of the testator and learn how to just argue those facts.
Yes. Okay. Good. I guess that's it. I really want to thank you so much, Walt, for your time. And
You guys feel free to leave a comment, and we'll try to reach out and answer any questions you can, or if there's a topic that you may want some clarification on, we'd be willing to help.
yeah, thanks so much, Walt. Thank you.
Thanks.
Okay.